Okay, good morning. I'm going to start. I am recording the class. Uh, Disappointing turnout, all of 3 students. I see Ms. Ngove has managed to join us in any event. Uh, then we have Mr. Kasutu and Mr. Meadow. Mr. Meadow, are you still abroad or have you returned to Namibia?
I'm still abroad. I'm only returning in November.
Okay, please, make sure. Okay, if you say you're returning in November, are you going to be back for the exams?
I'm not sure when the exam is written for business law.
Uh, okay, the exam timetable isn't available yet.
Oh, okay.
I will let you know as soon as I find out. Um, just remember, please, to contact. Maybe you should just work on the assumption at this stage that you will not be back on time.
Okay.
Contact the examinations department already now.
Okay.
Start putting things in place for you to be able, because you know it is a bit of a struggle. So maybe
Yes.
just contact them already now and start putting things in place.
Okay, I'll do so.
Okay. Okay, well, welcome to the 3 of you. Um, Assignment 1 has been marked. Trust you've gotten your results. Um, you should know, seeing that you're not first year students, that you can download your marked assignment. Yes, Mr. Kasuto?
Oh no, I was about to ask the question that you're literally answering now, so it's okay.
Oh, you can download your marked assignment. If you download your marked assignment, so not your original submission, the marked assignment, and you scroll, then you will see not just you'll see my mark allocation per question, you'll see my comments, and if you scroll down, right at the end of the assignment, the actual mark memorandum is attached. So all of that is available to you, my comments and the memorandum. So please compare your answers with the memorandum to see why you did or didn't get marks. Um, I was a bit disappointed in the assignments. I would really have hoped that by now, if when I said, and I'm not necessarily talking to the 3 of you at the moment, I'm talking in general. I'm teaching this class as if I've got a full class in front of me. I would have hoped by now that when I said, do your own work, students would start listening to me. I would have hoped by now that when I said, use only the study guide, every single answer you need is in the study guide. There is no need to do any research outside the study guide. But yet students are refusing to listen to me. They seem to still believe that they know better than I do. I got so many answers that were obviously generated by artificial intelligence, by AI. AI has a particular style of answering. It has a particular way of writing, which I recognize immediately. Answers are typically very long-winded, very vague. The moment I see that in an answer, I strike through the whole answer and I have a quick mark that says, not your own work. And I give you a 0. And that is so not negotiable. Still got identical assignments, people handing in identical assignments. Now, don't tell me you were doing your own work if your assignment is identical to somebody else's. So please, 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 assignment 2 is due shortly. If you do your own work and you use the study guide, you'll be okay. Don't try to increase your marks by sourcing answers elsewhere, because then you are not going to increase your marks, you're going to fail. Okay, so, sorry. That's my speech for the morning. Focus today is on partnerships, and I will also, I'm going to basically go through the whole section, all the units on partnerships very briefly, highlighting certain problem areas. And I will also, in doing so, address certain of the questions that are in assignment 2. Let me just get my slides. When you start going through these 5 units on partnerships, you will see, and it might originally start confusing you until you understand how it works. Okay, let me upload first. Can you see the slides? Just give me a thumbs up. Okay. Just meeting protocol while I'm teaching. I have the slides open on a separate window on my laptop. While I'm teaching, I'm actually looking at the window that has the slides, not at my team's class. If you have a question, raising your hand, I won't necessarily see you. So if you have a question, just switch your microphone on and speak up. Just interrupt me. So the way these units on partnerships are structured is there's a lot of repetition. And I think what I'm going to do for you after this class is to actually, but I'm going to be a little bit nasty when I do this. I want the 3 of you that have, this is my reward for the fact that you're attending this class. Please private message me after, because I don't have your individual phone numbers. You're just on the group, but please private message me and I will forward you the units on partnerships that I compiled earlier this year for the course that I'm now, that is sort of replaced business law for the accounting students. It's called Introduction to Law for Accountants, but it also includes partnerships. But the way I have compiled those units is a little bit easier to understand, but contains all the information, but there's less duplication. So private message me and I will send you the units from Introduction to Law for Accountants that relate to partnerships, just as additional assistance. I've found that the students find them easier to follow because there's less repetition. The way the units are structured in the business law study guide is I start with a bare bones, and then I add more info. In the next unit, I add more information. And then in the next unit, I add even more information. But which ended up confusing students because they would read things in, say, unit 13, and then they come to unit 14, and they think it's two different concepts where it's actually a repetition of the same concept with more information added. If you want to, private message me and I'll send you the notes from the ITL study guide. It's a little bit more compact, but it contains all the information that might make it easier for you to follow. Okay, so looking then at a partnership. Always remember to go back to your learning outcomes and discuss, make sure after you've been through the unit that you can address all these learning outcomes. So the first thing, obviously, you need to know is what is a partnership. Partnership, legal relationship arising from a contract between two or more, usually not exceeding 20 persons, terms of which each person must undertake to contribute towards an enterprise carried on in common with the object of making and sharing profits. Going to get back to this definition in a while. Not going to go through these slides, go through all my slides in detail, because then we'll still be in class by 4 o'clock this afternoon. So in this slide, it's essentially I've broken down that definition. This is just the same definition, but written in by way of bullet points. Contractual relationship between two or more, maximum 20 people. Each person must contribute. Business carried on for a common purpose with the object to share profits. Important aspect to remember here. The first thing that you need to understand is that a partnership is a contractual relationship between people. It is a contractual relationship between people, which means it is, if we get to the legal nature of a partnership, it is not a juristic person. It does not exist outside the partners. It doesn't have an existence on its own. And the very important result of this is that the partners are personally liable for the debts of the business. That is an important aspect. Partners are personally liable for the debts of the business. It stays relevant throughout the discussion, all the units, especially when we get to contractual liability of a partnership again, also becomes relevant in question 3. So just make a note of that. There is actually a question here, question 1.1. Explain the concept of joint and several liability. What is joint and several liability? This is not a concept, it's a legal concept which is not unique to partnerships. It's a general concept regarding legal liability, but it's also applicable to partnerships. Joint and several liability means that a creditor can sue any one of the former partners or all of them together for the debt. This can have far-reaching consequences. Let's say Mr. Meadow and Mr. Kasutu were the partners in the partnership. And we'll get to contractual liability of a partnership later. During the existence of this partnership, Mr. Kasutu entered into a contract on behalf of the partnership. Without Mr. Meadow knowing, he can bind the partnership. So this becomes a partnership debt. Now the partnership cannot pay. Zwico enters into a contract with the partnership. Partnership cannot pay Zwico. Zwico wants his money. The partnership has since dissolved because during the existence of the partnership, both partners, both Semedo and Kasutu, are liable for this debt. Partnership is now dissolved. Zwico's debt remains unpaid. Zwico can decide, because of joint and several liability, Zwico can decide who he wants to collect his debt from. He happens to know that Mr. Meadow is wealthy. She has a farm and a car and all sorts of things. Mr. Kasutu, not so much. Zwico can collect the outstanding debt from Mr. Meadow, even though she was not the one that contracted. Because of joint and several liability, he can collect the full outstanding debt from Mr. Meadow. And she must pay him. Once she has paid him, she can try to recover his share from Mr. Kasutu. But if he doesn't have money to repay her, that's tough luck to her. So joint and several liability, creditor can choose who to hold liable. Either an individual partner of his choice or all of them together. Very far-reaching consequences. Okay, there are some instances where the law recognizes a partnership as an entity. I'm not going to elaborate on that. The partnership fund, despite the fact that, let's go to that slide first, despite the fact that the partnership is not a separate entity, our law does recognize a partnership, the existence of a partnership fund, which can be described basically as the business assets. The existence of the partnership fund is important because during the existence of the partnership, if Zwico wants to collect his debt, he must first collect his debt from the partnership fund. If there are no assets in the partnership fund, he can hold the individual partners liable. So it's important from the point of view of a creditor to know which assets form part of the partnership fund. It's also important for the partners themselves to know which assets form part of the partnership fund. Not that important during the existence of the partnership, but upon dissolution of the partnership, creditors must firstly claimed from the partnership fund. Upon dissolution of the partnership fund, after all debts have been paid, whatever assets remain in the partnership fund are then divided between the partners. That incidentally is the answer to question 1.2. Why is it important whether a particular asset forms part of the partnership fund or not? It's important to know whether a particular asset forms part of the partnership fund during the existence of the partnership, because for creditors to be able to attach that asset upon dissolution of the partnership, so that this asset or the value of this asset can be divided amongst the partners after the debts have been paid. To determine whether a particular asset forms part of the partnership fund or not, between partners, so between Somedo and Kasuto, the important to determine whether an asset forms part of the partnership fund or not, the partner's intention is important. All partners that assets that they intended to be part of the partnership fund will form part. So there doesn't have to be formal transfer. For outsiders, however, there must be formal transfer. So if Somedo contributed a car, but that car remains registered on her name, so it wasn't formally transferred into the name of the partnership, Zwico will not be able to attach it. Upon dissolution of the partnership, however, even if it's still registered in her name, if it was the intention that it should form part of the partnership fund, it will do so, and it will be shared between the two partners. So either sold and the value split or whatever. During the existence of the partnership, partners own the assets in the partnership fund in joint undivided shares. So if there's $500 in the bank, that does not mean that Somedo has 250 and Kasuto has 250. They have $500 together. Upon dissolution, when it's shared, percentage that it's shared will depend on their initial agreement, whether they are equal partners or whatever. That's up to them to have decided at the beginning of the partnership. It's not relevant during the existence of the partnership, only becomes important upon dissolution when remaining assets are shared. Okay, I want to go on to the next unit. Any questions so far?
No, miss.
No, ma'am.
Okay, can just confirm, can you see the slides there?
Yes, ma'am.
Yes, ma'am.
Oh, we have another student that has joined us. Teteb Jr., welcome.
Hello, ma'am. Sorry for joining late. I had issues with my laptop.
It's not a problem at all. I'm just glad that you have joined us. I've been recording right from the start. After the class, also for the other students that haven't joined, I will, like I did with the previous class, I will share the recording on YouTube. I have a YouTube channel, so I upload the recording on YouTube. I find it's easier for students to access rather than having to access it through Teams. Sometimes they have problems getting the recordings on Teams. So I download the videos and share them on my YouTube channel. I'll also share the link. Otherwise, if you don't have the link, just go to YouTube and search Hanekom Law Lectures. And all my law lectures since the beginning of the semester are there. So the first bit that I did, Mr. Tovasuap, you can access by looking at the recording.
Yes, ma'am.
Okay,
I watched the previous one as well.
Good. Yeah, good. Mr. Tovasuap, sorry, I struggle with a click in your name. I'm not quite sure how to correctly pronounce your surname. What I did, the invitation that I extended to the other students in the class, after the class, please private message me and I will send you the notes on partnership that I compiled for the accounting students in the beginning of the year. They contain all the content, the information that is in the business law study guide, but I think the way I set it out, the way I compiled it is a little bit easier to understand. So I'll share those units with you as well. If you private message me, I'm not going to put them on. I'm not going to put them on the group, being a little bit nasty to students that didn't log in for the class this morning. That's just me. Okay, so Unit 13 elaborates on Unit 12. Unit 12 isn't that important. Unit 13 builds on the definition of a partnership, gives more detail about the different aspects. So we've already seen that a partnership is a legal relationship between parties which arises from a contract. So in Unit 13, we're looking at this contract. If you were asked, should you be asked in your end of semester examination to determine in a particular case study whether a partnership has come into existence, you need to check from this case study whether there was an agreement and whether this agreement contains the essentialia, the essential elements of a partnership. So firstly, the contract must be valid. All the requirements that you learned in commercial law for a valid contract: consensus, legal capacity, performance must be possible, performance must be legal. Performance must be legal. Not only must the actual object, the business of the partnership be legal, so you can't enter into a partnership with the aim of selling dagga. Companies Act has got a provision that relates to partnerships just with regard to the number of partners, restricted to a maximum of 20 people. No formalities required. It can be informal, doesn't have to be in writing. The essentialia, this is important. Contribution, joint benefit, and the object to make a profit. These essentialia are not present. It can be a legal association of people. I'm not saying it's illegal, but it will not be a partnership. In order to determine whether these essentialia, these essential elements are present, you need to know the requirements for each. What is a contribution? What does the law mean by contribution? What does the law mean by common business? What does the law mean by profit making? Contribution then, anything with commercial value. Doesn't have to be the same, partners don't have to contribute the same. Important aspect here, which relates back to the formation and the assets that form part of the partnership fund or not, is that, okay, now that I've highlighted it in yellow, you can't read it. Let's unhighlight. Partners can decide whether they are contributing the ownership of the asset or just the use of the asset. So if Mr. Meadow contributes her car as a delivery vehicle, she can, or she in conjunction, because it's an agreement, so obviously they must all agree, at the formation, these decisions are made when the partnership is formed, not later, 5 years later, when they've started arguing with each other. But she can decide whether she is contributing the ownership of the car, the actual car itself, or just the use of the vehicle. So the contribution can be either the thing itself or just its use. The general rule, however, the default position is that if a partner is contributing only the use of an asset, this has to be expressly agreed. If it's not stipulated, so if it's just silent, the general rule is that ownership is contributed. If ownership is contributed, it forms part of the partnership fund. Eventually, upon dissolution of the partnership, it is divided amongst, after the dates have been paid, divided amongst the partners. So this is obviously important, because if Mr. Meadow did not specify upon formation of the partnership that she is only contributing the use of her partnership, of the vehicle, that vehicle, she might still be under the impression that it's her car, only to discover that actually it is no longer her car, it is now the partnership's car. So, general rule, ownership will pass unless expressly stated otherwise. Even if ownership does not pass, obviously if she's contributed the use, she must make it available. It must be placed at disposal of the partnership. The contribution must also be subject to the risk of the business. So you cannot expect to get your contribution back. If you contribute $1,000, that $1,000 is going to be at the risk of the business. If you contribute but specify that in 3 years' time you want your $1,000 back, that is not a contribution, that is in fact a loan, and you will not be considered as a partner. you will rather be considered as a creditor. There must be a joint business, joint benefit of the parties. The essence of the fact that there must be joint benefit is that each partner gets to share in the profits. Another important aspect of the joint concept of joint benefit is that each partner should be engaged as a principal and involved in the decision making. This is a joint business. If everybody is just doing their own thing, it is not a partnership. Also, if one person is making the decisions and just giving instructions and the other people have to do this without questioning it, it's not a partnership, it's rather an employment relationship. If one partner gets all the profits and the others are just sharing in the losses, it's not a partnership. So they must be sharing, that does not, if I say there must be a joint benefit, however, don't get confused here. That does not imply that the partners cannot between themselves to appoint, say, a managing partner. The partnership that we had beginning of the class for illustration purposes between Kasutu and Somedo, they are welcome to decide that Kasutu will be the managing partner who runs the business, as long as Somedo is also still part of the decision making. But if Kasutu is making all the decisions and just giving instructions to Somedo, that would rather be an employer-employee relationship rather than a partnership. So if I'm saying it's a joint business, it doesn't imply everything must always be absolutely equal. But there must be this element of working together, equality, equity. And then profit sharing. By profit sharing, I'm referring not to just the business making a profit in general, but that profit must be for the personal benefit of the partners. So a charity organization, a sports club or whatever. So if Kasutu, Somedo and Elifas decide to start selling sandwiches to raise money for the NUST netball club, it's perfectly legal. They may do that. Maybe they've all contributed. They've all put in some cash to go and buy bread. They're working together. They make the sandwiches together. They're selling it together. There's a joint business. But the fact is that if they are raising that money for NUST netball club, it's a legal business. They may legally do this, but it's not a partnership. It will only be a partnership if that money that they make by selling these sandwiches is eventually shared between them for their own personal bank account, their own personal back pocket. So there must be profit sharing. Profit sharing does not have to be equal. Important mistake that students often make. If I give them a scenario, case study, saying that they work together, whatever, and then eventually things didn't work out the way they wanted it to, and they made a loss. So there was no actual profit made, they made a loss. Students will say, but then this is not a partnership because there must be profit sharing. No, that's wrong. There must be the potential to share profit. If the business suddenly, due to circumstances, makes a loss, that doesn't mean it suddenly stops being a partnership. It remains a partnership. And that's where the whole issue that I discussed right at the beginning of the class about joint and several liability comes in, where all three of them can be held jointly and severally liable. If it suddenly stopped being a partnership, they wouldn't be jointly and severally liable. And from a legal point of view, obviously that doesn't make sense. So it's not a requirement that the profit must actually ensue, but there must be a hope. It must be capable of making a profit, and each partner should at least have the hope of sharing. So those are your three essential elements. If those three essential elements are present, it will be a partnership. If it's a partnership, once we've established that it is a partnership, I've just looked here at the tutorial later. What are the legal rules regarding sharing of profits? Okay, so we'll get to that later. If those three essential elements are present, it is a partnership. Once it is a partnership, there are certain natural legal consequences, naturalia, that flow by law, by operation of law, from the fact that it is a partnership. Because these are naturalia, naturalia can be changed, but then they must be changed expressly. So these are legal consequences that will apply unless expressly changed. Okay, so this is, here we are within question 1.4, proportion in which the profit is shared. We know now that profits must be shared. How much does everybody get? Firstly, profits are shared according to their agreement. So they can agree that Eliphas gets 50%, Semedo 30%, and Kasuto 20%. Doesn't have to be equal. They can agree whatever they want to agree. If there's no express agreement, profits will be shared in proportion to the value of their respective contributions. If, however, the value of these contributions cannot be determined, so one is contributed money, but the other one is contributing labor, and you can't put a price on that labor. So the value of the contributions cannot be determined, profits will be shared equally. For the purpose of question 1.4, it is important to get maximum marks for question 1.4 to put this in sequence. So don't start off by telling me it is shared equally and then they can agree. No, that's not how it works. They can agree, or it's in proportion to the value, or if not, it's shared equally. That is how the naturalia works. So please, if you answer question 1.4, make sure to list these points in the correct sequence, the way I have it here, because that is how it works. You first look if there's an agreement. Then you look if you can ascertain the value. If not, it is shared equally. So don't start off by telling me they share equally. Sharing of losses, same thing. There's additional point here. According to their agreement, there can be separate agreements. Important to understand this. There can be separate agreements with regard to sharing of profits and sharing of losses. They can agree that partners can agree that the losses that Kasutu will get 50% of the profit, Samedo 30%, and Ilifas 20%, but that losses will be shared equally, so 1/3, 1/3, 1/3. Remember, might sound unfair. I have students saying, but that's unfair. How can he get more profits, but we all have to and only share in a little bit of the losses? It's not unfair, because a partnership is an agreement. It is an agreement between the partners. And if that is what you have agreed, you cannot subsequently turn around and say, but it's unfair. Partnership is not an employment relationship where partners are not on equal footing. If you enter into a partnership, you are negotiating as equals. So if you're not happy about it, speak up and say, no, I'm not happy with him getting all the profit and me carrying all the losses. So you can't turn around and say it's unfair if you willingly entered into that agreement. So there can be an agreement with regard to losses, and there can be an agreement with regard to a separate agreement with regard to profits. So losses are shared according to the agreement regarding sharing of losses. But if there was no separate agreement, it will be shared in the same ratio as which the profits were shared. Not all partners have to share in the losses. You can exclude one or more, but there must be at least one ordinary partner who actually shares in the losses. Okay, the other naturalia concern the power of representation. Each partner may represent. These particular naturalia are described in more detail in further units. So I'm going to discuss them in more detail in the next slideshow. Power of representation. Every partner has the right to represent the partnership in contracts. Just give me a second, please. My apologies. My company law students are doing an online test, an online quiz. They're test 2 at the moment, starting as from 10 o'clock. And I was just concerned that that was a student that might have phoned because they cannot access the test. I'm going to be back with you in a second. Okay, sorry, just wanted to make sure that there aren't any problems with the test. So, yeah, where was I? Okay, so we were looking at power of representation, no compensation for contribution. Partners have to contribute to the partnership. That's one of the essentialia. Your contribution is just that, your contribution. You can't expect to, in most instances, you can't expect to contribute and get paid for your contribution. Your compensation lies in your profit sharing. This can, however, be changed. All these naturalia can be changed. Remember that. Then co-ownership, I've already spoken about that. So it's a repetition of what I said when we were talking about the partnership fund. Partners are joint co-owners of the partnership fund. They own the partnership fund in equal undivided shares. Once again, this can be changed. As I stated earlier, you can contribute only the use of the particular contribution, just the use of the vehicle or the use of the building, but then that must be expressly specified at the time that the partnership is formed. Otherwise, the default position would be that you are contributing the ownership. So, as I warned you beginning of the class, saying the same things over and over again. Okay, let's go to the next unit. Okay, unit 14, the rights and duties of partners. Okay, so the rights and duties of partners. The sources of the rights and duties, question 1.5. Sources of the rights, where do these rights and duties come from? Obviously, partners can agree in their partnership agreement on specific rights and duties for the individual partners. Because every partnership agreement can be different, we don't look at specifically rights and duties arising from a specific partnership agreement, but remember to mention that in question 1.5, sources of rights and duties can come from the partnership agreement. More importantly, the duties that we look at are the common law rights and duties of partners, those that arise from not specific duties from the partnership agreement, but the legal consequences, duties that arise from the essential elements of a partnership, as well as rights and duties that arise from the naturalia, the natural legal consequences of a partnership. Every right has a corresponding duty. So that's why the heading is rights and duties, but they're not separate rights and duties. If Zwico has a duty, that means Semedo has the corresponding right. If Eliphaz has a right, then Zwico has a corresponding duty. The most important duty of partners is the duty of good faith. It's referred to as a fiduciary duty, but you don't need to remember the word fiduciary. Fiduciary means the same as good faith. Partnership is a contract of utmost good faith, mutual trust, and confidence. And the law takes this very, very seriously. Duty of good faith implies that every partner must accept and fulfill all the obligations imposed on them by the partnership agreement. They must promote the business of the partnership unselfishly. They may not keep anything to themselves. They must avoid at all times a conflict of interest. They must always put the best interest of the business first, above their own potential benefit. They must sacrifice their own potential benefit to the advantage of the partnership. You may have another business, may be involved in another business, but you may not carry on a business in competition with a partnership. So if the partnership is in the business of selling shoes, you cannot have your own separate shoe shop as well. Any benefit or advantage which falls within the scope of the partnership business must be shared with the partnership. So you cannot make use of business opportunities for your own purpose. Business opportunities that you find that come to your attention must be shared with the rest of with the partnership as such. It is a duty of utmost good faith. Go back to that slide. A contract of utmost good faith, mutual trust, and confidence. A second duty that partners have is, let me just get to that slide. I'm going to get back to this, but I want to find this particular slide. This one. Because students often confuse these two duties. Don't confuse them. Partners have a duty of utmost good faith. Utmost good faith, the highest level of good faith. They also have a duty of reasonable care. And do not ever mix together the duty of good faith and the duty of care, and skill. Duty of care is just the fact that partner must display reasonable care during the running of the partnership and in the manner that they use the partnership assets. If they are found to be negligent, then they can be held liable for damages. The law does not, where it requires utmost good faith, it requires only reasonable care. So it's not a particular strict standard. No special skills or qualifications or talents are required. If we go to question 2.3, I'm going to get back to, after I've been through all the units, I'm going to get back to the assignment and just make some comments to guide you on the assignments. But question 2.3 specifically, question 2 says, briefly discuss the following statements. The affairs of a partnership must be handled with great care and skill by the partners. In question 2, in general, you must, I'm asking you, I give you statements and I ask you to discuss them. You need to, as starting point of your discussion, you need to point out to me whether this statement that I'm giving you is correct or incorrect or just partially correct. And in each of those 3 statements, there's actually a catch. These are trick questions. The statement that I give you in question 2.3 says, the affairs of a partnership must be handled with great care and skill. That is incorrect. That statement is incorrect. The law does not require great care and skill. It requires reasonable care and skill. There's a difference between the utmost, highest level, great, or just reasonable. So if you're answering question 2.3, that question, that statement that I'm giving you there is actually incorrect. No, the law does not require the affairs of a partnership to be handled with great care and skill. It requires only reasonable care. Don't, as I've said before, confuse good faith with care and skill. Let's just look at some of the other rights and duties, because I jumped this slide now. These are all still part of the duty of good faith. Carrying on the business, that's fairly obvious. Is a joint business after all. Do whatever you're required to. Make your contribution available. In general, there is no compensation for your contribution and no payment for services rendered, because it lies in your profit sharing. But whenever I say in general, it means it can be changed, and partners are free to agree that there will be compensation, that one or more might receive a salary, payment for extra tasks. Partners can also claim refunds if they spend their personal funds. That brings us to question 2.1. Question 2.1, a partner never has the right to claim compensation for his contribution to the partnership. Once again, that statement is incorrect. You cannot say they never have the right. In general, they don't have the right to claim compensation, but they can freely agree otherwise. Okay, sharing of profits and losses, that's a repetition of what we've already done. Use of the partnership assets, we've already seen that the partners are joint co-owners of the partnership assets, which means the assets belong to all of them together, not to individuals. They're entitled to free and undisturbed access, but do not have exclusive control of any partnership asset unless this was specifically agreed. Partnership assets, they can all use the partnership assets, but for business purposes, not for private use. Private use only allowed to a limited extent if it will not conflict with the interests of the partnership. A partner who uses partnership assets for their own purpose without the permission of the co-partners can actually be charged with theft or face a potential claim for damages. And then management, we're getting back to this. This was also in the previous slideshow. And we look at this again in the next unit. General concept is every partner has a right to share in the management of the partnership without consent or permission of the other partners. General rule is they all have equal say, but this can be changed. At law, they all have implied authority to represent the partnership, to conclude transactions on behalf of the partnership, and to bind the partnership. They have the right to all the necessary information, the accounting records, and must inform their partners of any business dealings that they did on behalf of the partnership. Everybody still with me? Because I'm going quite fast. Any questions so far?
No, ma'am.
On my side.
No, ma'am.
Okay, Unit 15, representation of a partnership. This is a very important unit. Let me just share quickly. Okay, representation of a partnership. Unit 8, not Unit 15, question 3. Question 3.1 concerns representation of a partnership. And I can also promise you that this will absolutely be in your exam. This is a very, very important unit for two reasons. For practical purposes, in the first instance, a partnership is all about doing business, making a profit. You cannot generate money, you cannot make a profit if you do not enter into a contract. And because the partnership is a collective of people, the question arises, when will a contract entered into by an individual partner bind all the other partners as well? When will a contract entered into by Elifas also bind Kasutu, Semedo, and Zwico? Far-reaching consequences, because if the contract binds the partnerships, all the partners, and the partnership dissolves and there's still outstanding debt, they all become jointly and severally liable. If the contract did not bind the partnership, but only the individual partner, then of course there's no joint and several liability. So you will understand how important this is. So in order for a contract entered into by an individual partner to bind the collective, there are 3 requirements. The contract must be valid, must be concluded in the name of or on behalf of the partnership, and it must be authorized or fall in the course of the business. Those first 2 requirements are fairly straightforward, self-explanatory. Contract must be valid. Go back to Commercial Law 1A, requirements for a valid contract. Concluded in the name of, on behalf of the partnership. I will always give you that information in a case study. Remember, if you want maximum marks for this question, you have to address those requirements. You must tell me that the contract is valid and it was concluded in the name of the partnership. You don't have to discuss those requirements in detail, but you do need to address them. With regard to authority, so the requirement that I'm going to elaborate on is that one, that it must be authorized or entered into in the course of the business. So the contract must be authorized. Revision of Commercial Law 1A when you did the law of agency. There must be authority. Authority can either be actual authority or ostensible, apparent authority. Actual authority can be either express or implied. Make sure you know the difference between these types of authority. Express authority, a specific instruction to enter into a specific contract. If there's express authority, the contract, the partnership will always be bound. So if all the partners agree that Zwico must go and buy a boat, then they will be bound to that contract to buy the boat. Implied authority is authority that comes with the job. All partners have implied authority or start off by having implied authority because they are partners. We've seen this in 2 previous slideshows. It is a natural legal consequence of the partnership agreement that partners are entitled to participate in the management of the partnership. Implied authority covers all acts that are necessary for the proper conduct of the partnership business. So all partners have the inherent right to bind the partners in contracts relating to the business of the partnership. But because this is a naturalia, it can be changed. It can be changed. So the partners can agree that in this partnership, only Ms. Semedo has the right to enter into contracts to bind the partnership. If they have agreed, and this is important that you understand this, if they have agreed that only Ms. Semedo has the right to bind the partnership, that means that Kasuto, Zwico, and Elifas no longer have implied authority. Although they are partners, they don't. Implied authority can be taken away. And if you take something away from somebody, they don't have it anymore. So if you've agreed that only Semedo may represent the partnership, Kasuto, Zwico, and Elifas no longer have implied authority. And you will recall, or I hope you will recall, from when you did the law of agency in commercial law, that if there is no authority, the principal, remember the principal in this instance is the partnership. If there's at common law, in terms of the law of partnerships, if there's no authority, if the contract is unauthorized, the principal will not be bound. However, in partnerships, in partnership law, it works slightly differently from what it would if you were talking about individuals. If Somedo entered into a contract on behalf of Kasuto without authority, Kasuto is not bound. If it's a partnership, however, our law recognizes what is referred to as the mutual mandate. And third parties, outside parties, can rely on the mutual mandate to hold partners liable for unauthorized contracts. So the contract remains unauthorized. It doesn't somehow suddenly become authorized because that authority, that implied authority, was taken away. So if you agreed that only Somedo has implied authority and Kasuto enters into a contract, he doesn't have implied authority. The contract is unauthorized. But if it is in the scope of the business, just a repetition there of what I've been stressing, if there are limitations or restrictions, there's no implied authority, the act is unauthorized. But in terms of the mutual mandate, a partnership can be bound to unauthorized acts if they fall within the scope of the business and the third party was not aware of these restrictions, did not know. The rest of these slides, I'm not going to go through them. It's just some common mistakes that students often make, but I've stressed them. Common mistakes that you make where you're going to be losing marks if you say there's implied authority because the act is in the scope of the business. The fact that the act is in the scope of the business doesn't mean there's implied authority. It means that the partnership is bound to an unauthorized contract. Another common mistake, contract is valid because it's in the scope of the business. No. 5 requirements for valid contract. You studied those in commercial law. Scope of the business isn't one of them. The contract is binding because it's in the scope of the business. Watch your words. Words are important in law. Ostensible authority. I've just realized here, I've been saying you did agency in commercial law. That's not correct. Even better, it's actually part of the first part of business law, Unit 8. Go back and read through Unit 8 again. Ostensible authority. Also, third parties can also use ostensible authority to hold a partnership to a contract. That is where there was no authority. The contract is unauthorized. But the partnership created the impression that there was authority. And then ratification, that is where there's no authority or there was no impression of authority, but the partners want to be bound so they can ratify the contract. If the contract is in the scope of the business, there is no, students often say it's in the scope of the business, so they must ratify. Absolutely not. No, 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 no. If it's in the scope of the business, the partnership is bound. You can never say they must ratify. Ratification is never a must. Question 2.2. If a partner enters into a contract on behalf of a partnership without having actual or ostensible authority, the partnership must ratify the contract. No, that statement is absolutely incorrect. If there's no authority, be it actual or ostensible, the partnership is not bound. There is no such a thing as they must ratify. Ratification is never a must. Liability of partners, this sets it out quite clearly. So I'm not going to read the slide for you, but this particular slide is relevant for the rest of question 3, question 3.2 to 3.5, or 3.2 to 3.4 actually. You can find all the answers to those short questions, little 3-point questions, 3-mark questions. All the answers are there. Okay, any questions? So that's essentially the work that I wanted to. We've been busy for about an hour and a half. Time has passed quite quickly. I don't want to keep you much longer. Any questions? Any questions about the work so far?
No, ma'am.
Okay, just briefly in conclusion then, if we get back to assignment 2, which is due shortly. Question 1, these are all straightforward knowledge-based answers. Questions. Answers are in the study guide. What's your mark allocation? If it's a 3-mark question, maximum 3 lines. If you have to list something, you don't have to discuss it. A list is literally a list. So straightforward questions there. Don't use ChatGPT or any other version of AI. I will catch you out and I will give you a 0. Another particular thing about AI is answers are always very long. If it's a 3-mark question and you give me an answer that is half a page, I'm going to strike it out and say not your own work. Because it isn't your own work and it's probably incorrect as well. What's your mark allocation? Question 2 then, briefly discuss the following statements. As I've said, in each instance, indicate whether the statement is correct, partially correct, incorrect, or partially correct, and motivate why. Explain what you say that, or explain what the actual legal situation is. I have, in fact, in the course of the class, answered all 3 of those questions for you. Then Blossom and Buttercup, question 3, 3.1, contractual liability of a partnership. We've just done that. And for the other short questions, those answers are available in that one slide that I showed you. All these slides are on e-learning. You can download my slides from e-learning. They are there. Any further questions? If there are no further questions, thank you so much for joining the class. I will upload and share the recording if you want to listen to that again. Spend the rest of the time finalizing your assignment 2. Do your own work. Do your own work. Don't copy from other people. Don't buy assignments. You will fail. And this is the last time, the last opportunity that you have to pass business law. Business law will, as from next year, no longer be offered. So if you don't pass now, you have to transition to the new entrepreneurship program, which will have the result that you will have to catch up certain subjects. Okay, thank you so much. Have a wonderful day. Ms. Meadow, please remember to contact the examinations department timeously to make arrangements for you to write your exam in Germany. Thank you. Bye.
Bye. Thank you, ma'am.
Thank you, ma'am.